clarification from either the Minister or the Attorney General as to whether the license being talked about here covers the laborers. Why do I say this? The sugarcane industry has relied on cheap labor from West Nile for a very long time. Even from Acholi, there's a man who worked for 47 years. The only thing he went back with is a bicycle. And now, I will, if it covers, move that during the consequential amendment, I need the laborers to be part of the council. Because we don't want exploitation anymore, the minister should clarify whether the license being talked about here covers those who will supply labor or covers the labor to the sugarcane industry.
Yeah. Attorney General, I want you to liberate West Nile from providing cheap labor.
I can understand that, but I think we may stray into a space that is we may not be able to regulate, because labor is offered freely. A person cannot be required to provide the labor they do not wish to provide. Now, if you say that we should have the laborers in here, then they have become participants in the business, which they are not. So I think what we can do is we have sufficient provisions in the Employment Act which address any challenges that an employee may have in our Employment Act and the necessary labor legislation.
So the Attorney General made a request that if we could handle clause 20 and 21, then it would help us on the other clause, so that we don't amend in anticipation. What if the other ones are not amended? We just have them as consequential clauses. So I would propose that.
Chair, I think my issue is not addressed to my satisfaction. Why? What is happening is you have companies that go and pick people from the villages, and then they come and give them to the sugarcane industry. And oftentimes, nobody is speaking for these people. I think if we want to regulate the industry and get value from it, we must ensure everybody in the value chain gets benefit. And that means we must be able to regulate the activities of people who supply this kind of labor, and there must be guarantee for those. That's why I was saying there is need for these people to be represented if the license they are so covers that kind of activity.
Honorable, issues of employment, please, the Attorney General guide, the Employment Act, let us not mix roles, okay? Let's be very clear. Chair.
Amendment of Section 20 of Principal Act. Section 20 of the Principal Act is amended in Section 1 by substituting for the word board, the word council.
Chair, when you propose an amendment, you give a justification.
Honorable Chair, to harmonize the provision of Section 19, 20, and 23 with the principle of the bill relating to the grant of licensing by the Minister on the recommendations of the Council. To penalize a miller who pays below the price set by the formula by having his or her license revoked by the Minister. The requirement is to establish a sugar planting capable of supplying at least 50% of the installed capacity of the miller, is to ensure self-sustainability in the period where there is insufficient supply of cane from outgrowers.
Thank you, Chair.
Submit.
Attorney General.
Thank you, Right Honorable Chair. We have no objection to the proposed amendment in Section 20 to replace board with council.
Thank you. Honorable colleagues, I put a question that Section 20 be amended as proposed. Those in favor say aye. It came in as a new clause. Honorable colleagues, I put a question that a new clause be inserted as proposed. Those in favor say aye, and to the contrary nay. The ayes have it.
New clause.
Honorable colleagues, I put a question that the new clause stands part of the bill. Those in favor say aye, and to the contrary nay. The ayes have it. New clause, Chair, 21.
Amendment of Section 21 of the Principal Act. Section 21 of the Principal Act is amended.
Yes. A new clause. You're amending 21, Section 21 of the Principal Act. So we needed to insert.
Okay, insertion of a new clause. In subsection 1 and 2, by substituting for the word board, the word council.
That one we've already passed.
We have
Chair.
passed, yes. There is an insertion by inserting a new subsection immediately after subsection 7 as follows. I beg your pardon, Chair. By inserting immediately after subsection 3 the following. 3A. The council shall, within the time prescribed by the minister, by regulations, consider the application and make a recommendation to the minister to grant, to not to grant a license. 3B. Whether the council does not recommend a grant of a license to the applicant, the council shall, in writing, notify the applicant of the decision. 3C. The applicant shall, within 30 days of receipt of the notice of the decision of the council made under subsection 3A, apply to the minister for redress. 3D. The minister shall not make a decision on the application for a license where the council refuses to recommend a grant of a license to the applicant until after the expiry of the time prescribed in 3C. In subsection 6 and 8, by substituting for the word board, the word minister.
That is C.
Yes.
Because it is important for numbering, Honorable.
That is C. I've ended there.
Yeah. D in your...
I have read it.
D? Because you've stopped at C. D. Chair, can you
A,
read
B,
D?
C, D. I read D, Honorable Chair.
Can you read D again so that I'm with you?
The minister shall not make a decision on the application for a license where the council refuses to recommend a grant of a license to the applicant until after the expiry of the time prescribed in subsection 3C.
Then C.
The applicant shall, within 30 days of receipt of the notice of the decision of the council made under subsection 3A, apply to the minister for redress.
You know, I read through your report and I received everything, so I try to reconcile to ensure that what is in the report is what you're reading here. So just let me consult here the report.
Okay.
Chair, if I may consult with you and AG, just a little. Chair, resume.
In subsection 6 and 8, by substituting for the word board, the word minister. By inserting a new subsection immediately after subsection 7 as follows. 7A. A miller shall, within the time prescribed in subsection...
Chair, I'm sorry for interrupting you, okay?
Yes, Honorable Chair.
But now, you see, they have to number when they are polishing and coming with the law. You have C. In subsection 6 and 8, by substituting for the word board, the word minister. Then D, by inserting a new, you get it, eh? So give me the detail of each. Where you have a C, where you have a D, we capture it on the record.
Okay. So 7A.
That's under D.
That's, yes, under D,
So it
7A.
starts with D.
Okay. A miller shall, within the time prescribed, 7A.
Chair, let me see your.
Thank you so much, Chair. C.
Colleagues, Chair, Chair took over this in between. So the way the report had been captured, and so she's doing a great job.
Thank you so much, Chair. Continuation on C. C, in subsections 6 and 8, by substituting for the word board, the word minister. D, by inserting a new subsection immediately after subsection 7 as follows. Chair, 7A. A miller shall, within the time prescribed in subsection 7, establish a sugarcane plantation capable of supplying the miller at least 50% of the miller's installed crushing capacity. E, by substituting for the section 9, the following. 9A. A person aggrieved by the decision of the minister may apply to a court of competent jurisdiction to review the decision of the minister.
Thank you.
Justification, I read again, I had read them earlier. Justification, to harmonize the provision of section 21 with the principle of the bill relating to the grant of license by the minister on the recommendations of the council, to provide for a procedure for grant of license by the minister, to empower a person aggrieved by the decision of the council not to recommend him or her for grant of license to seek redress from the minister. The requirement, I could finish, Honorable Chair. The requirement to establish a sugar plantation capable of supplying at least 50% of the installed capacity of the miller is to ensure self-sustainability of millers in periods where there is insufficient supply of cane from outgrowers in order to ensure security of supply of sugarcane to the suppliers. I beg to submit.
Thank you. Government?
Thank you very much, Right Honourable Chair. Right Honourable Chair, we do not have a problem with the proposed amendment A to subsections 1 and 2. We have no objection to the amendment B in as far as 3A is concerned. the committee report reads that the council shall, within the time prescribed by the minister by regulations, consider the application and make a recommendation to the minister to grant, and it has two instead of to grant or not to grant. Right Honorable Chair, we have an objection to...
That's a clerical
correction. It was just two replaced by or, but for 3D, we would seek members to reconsider, the committee chair and members to reconsider, because it reads, the minister shall not make a decision on the application for a license where the council refuses to grant a license to the applicant until after the expiry of the time prescribed in 3C. Right Honorable Chair and colleagues, 3C relates to the time within which a person aggrieved by a decision could apply to the minister. So once a person applies to the minister, the operation of 3C has ceased. So we're proposing that 3D be dropped because the decision of the minister when made, they are proposing that that can be appealed to the court as you go further down. We have no objection to the rest of the proposed amendments to section 21.
Thank you. Yes, Honorable Adiomu first. Yeah, the reason first. Yes, Honorable Adiomu.
Thank you, Honorable Chair. Honorable Chair, that's why I had that worry of repressing the body with the minister. You know, there is a situation whereby they wanted to create zoning, in that by giving all the powers to grant or not to grant to the minister, then it will create a situation of zoning, because a minister can either grant in a certain radius that maybe we are not granting this factory to come here or this miller to put here a factory. And by doing that, it will be one way of indirect way of creating zoning. So I think I'll go by the chair's recommendation that the minister should not have a decision against the council. Why? Because already we have the council, and one of the whatever, and the council has the mandate. And if we are saying that the council is having the mandate, but again for their, one of their mandate is just to recommend to the minister, meaning that the council will not have anything to do. Thank you, right, Honorable.
Attorney General.
I think if my colleague is agreeing with the committee, then he's really agreeing with me, because I just agreed with the committee. The only thing that I said was that the minister, D, remove D. So we are on the same page.
Chair, I'm saying that we should not remove D, because D is saying that the minister should not have a decision, or to reject a decision of the council.
Honorable Attorney General, okay. Just to arrest the fears of the member, I need you to reply. The member is saying that if the council recommends that company A be granted a license in this area, okay, the minister should not have powers to reject the decision of the council. That's what I'm picking, because the member is fearing this minister, because it's like a self-regulated industry. So he's saying if the council gives, the role of the minister would be to issue the rights.
I think here we need to agree, and I agree with the member that the minister may hold a different view from that held by council. But why? That's what we are saying. That's why we are talking about dual processes. The council makes a recommendation to grant or not to grant. So if the council makes a grant, and the minister says, I don't think it is correct, you don't have a problem with that. But if he says the council refuses, because the argument we are having here is that even the council itself, what you are trying to to prescribe against the minister, even the council itself could be a subject of that same issue. So here what we are saying, let me finish. Here what we are saying...
Honorable colleagues, I'm going to give you time, okay? Let's allow one another. When one is on the floor, we give them time. Yes, so when one is on the floor, we give them time, they finish, then I allow you.
So
let's listen. Yeah.
What the minister, what the committee has done, it has said council sits through the application. So in the application process, the minister is not participating. The council makes a decision. The only way the minister gets involved is when a person is aggrieved. An applicant, if the council sends a recommendation to the minister to grant or not to grant, and the person who applied does not complain, the minister can't get involved. The minister can only do that which the council has recommended. But this clause is saying where the applicant is aggrieved, he goes to the minister and says to the minister, the council has mistreated me for these reasons or those reasons. And then that is when the minister can get involved in making a determination whether to grant or not to grant. But the committee has gone further to say that even when the minister has made that decision, if a party is aggrieved, maybe now the council is the one that doesn't agree with the decision of the minister, it can then apply to the court to review that decision. So it's important, colleagues, that this applicant has got a remedy provided to them in case a decision is made which they don't agree with. Beg submit.
Thank you, Honorable Joab.
Chair, I want to agree because the minister is a minister of government. And the spirit behind this amendment is that the minister is deemed to be as neutral as possible. But the council has interest because it is in business. Yes, in fact, in the council, like we have the millers, we have the growers, and we have the representatives of the minister. But this council, to me, I feel can be more biased when it comes to recommendation status.
Thank you.
Yeah.
Now, honorable colleagues, I don't want us to have an exchange on this because Attorney General has put it very clear that the minister will only be involved if a party that has applied is aggrieved. Okay? And where are the situations of being aggrieved? They've denied me a license. I applied to the council, they denied me a license. Honorable Batua.
Thank you, Right Honorable Speaker. I seek clarification on that very matter. The principal act that we are managing, that is the section
we are not managing here. We are.
The principal act we are amending, that is section 21, has only 3 subsections. However, when you look at the suggestion of the meeting, it is citing subsection 6 and 8. And in those 2 subsections, first I should confess that we are blind as to which 6 is talking about and as to which subsection 8 is talking about. And in being that blind, we now see that the word board in those 2 subsections where we are blind should be replaced or substituted with the word minister. So we wonder the functions that should have been of the board that actually are going to the minister. And if those 2, if subsection 6 and 8 is listened to properly, maybe it will clarify the position the minister is trying to state. So I ask that the committee rereads subsection 6 clearly and subsection 8, and we see its effect.
Don't accept to be blinded. It's very simple. When you're introducing something beyond what is already provided, that's why it becomes a new clause. So when you're having a new clause, you can go beyond, okay, what was provided in the, what is in the Principal Act. For example, if the clauses being amended around section 21AB, okay, And you have new ones. You can add on, you go to C, E, F, G, and all that. That's number one. Then 20, we agreed that we shall come to it later because it's a consequential amendment. Once we agree that the powers of the license don't stop at the board, but go to the minister, okay? Then we must go back to 20. So it's a consequential clause, but it can only be consequential if we agree with section 21 and 22. Once we finish those ones, then you will have amended the other ones indirectly, so you must go back and you amend. That's 19, section 19. Yeah. I had, Honorable Wakamba, you had an issue on the same. Then Honorable Taylor.
Thank you, Chair. I have a problem with the proposal because Machias Delande Attorney General is saying that it can be dual, but the section says if the applicant is aggrieved. We may need to change to say the aggrieved party. Then it can cover both the applicant and the board in case the board is aggrieved with the decision of the minister.
Attorney General.
I think if and C relate to the applicant. If the applicant is aggrieved, if the applicant goes to the board, makes an application for a license, and the board, for example, says no, the applicant is aggrieved, and the applicant can go to the minister. But if the board is aggrieved, rather if the council is aggrieved, you go to 9, which says the insertion that the committee is proposing, a person aggrieved by the decision of the minister, whether it's the applicant or the council. You go to 9, that's when you apply to the court. So the aggrieved parties can be 2 in respect to a decision of a minister, but the aggrieved party can only be 1 in respect to the decision of the board. Of the council, sorry.
Honorable Taylor.
Honorable Chair, the spirit of creating the council with the composition of farmers and millers is to create a self-regulating entity that shall give very proper guidance to the sector. The reason why we are not comfortable with the view that the decision of council should be vetoed by the minister is because we do not, first of all, want to politicize the sector. We want it to continue self-regulating in a business manner. But number 2, it is more convenient for an individual to go to court in case he's aggrieved than getting the consensus of council members whom probably if the matter was put to vote and 4 are saying yes and 3 are saying no, these ones will even oppose the resolution of council to go to court when they are going against the decision of the minister. So we rather say the aggrieved party should go to court than having the council to go to court against the decision of the minister.
So that the powers of the minister is only of granting a license on recommendation of the committee. Honorable Chibadia.
Thank you, Chair. Chair, you remember very well when we were in the consultative meeting you called. And these are the scenarios we tried to avoid. That's why you called it those meetings. And the Honorable Minister, Honorable Bahati was in the meeting. And we agreed clearly that the powers of the minister will be to grant after the council has agreed. We are putting a scenario where we are giving also room for the minister is also having space to say if the council says no, I can say yes and we can find a way. Or if the council says yes, I can say no. This is what we are discussing here now, Chair. I would request, we agreed in principle that the minister will take the decision of the council. The minister will not sit in office and also do something different from what the council has done. That's why we say that if there is any party that will be aggrieved, that party will go to court. That's what we discussed.
Haj Idi.
Thank you, Right Honorable Chair. Chair, the consultative meetings that you held, we are trying to cure such scenarios. Because if you consider the Principal Act, we are only replacing the board for council. So what the board ought to have done in the Principal Act, that is exactly what we would expect the council to be doing. So if we are giving a minister room also to determine whether to be a board or council, I think when the council recommends, because the council is the regulator, the promoter of the industry. So I would really ask the Attorney General information.
But Honorable colleagues, I'm allowing you time to debate. Now when you interrupt each other with information.
Yeah, thank you, Chair. Chair, the information I wanted to give, that the minister in the council is already represented. The minister is already represented. There are 3 members representing the government.
So let's
meaning that if again somebody who is having a representative, again you are sending the same person to take the decision where his representative is.
Haji, just wait a bit. Haji, honorable colleagues, we had a long process that members are referring to. A long process. So if members are saying that if you are aggrieved by the decision of the council, you go to court. Are you getting me? Yes. You can go to court. This didn't come from government. This came from the committee. It's not a provision of government. So chair of the committee. No, it was not your provision. It was a chair. It was a provision of the committee.
Thank you so much, Chair. Chair, we concede. On 3C, the applicant shall within 30 days of receipt of the notice of the decision of the council under subsection 3A apply to, the honorable colleagues are saying apply to a court of competent jurisdiction to review the decision of the council. That should be the council, not the minister in this case.
Yeah.
So we agree to that.
Honorable colleagues, I put a question that the new clause as proposed be inserted. Those in favor say aye, and the contrary nay. The ayes have it. We can go back to clause 20. Colleagues, we've already moved on from that. Can we go 20? Consequential, 19. It's 19, consequential amendment. Can we go to 19? Honorable colleagues, when I put a question, allow me to move, okay?
Amendment of section 19 of Principal Act. Section 19 of the Principal Act is amended by substituting for the word board where it appears the word minister.
That's a consequential amendment. Yes. Honorable colleagues, consequential amendment, you don't discuss it because you've already passed 20 and 21. Yeah. A consequential amendment? No, please. That cannot be a consequential amendment. That becomes
Chair, if you just allowed me.
Honorable colleagues, you see, go to our rules. When you hear why I was referring to members, the moment you want to propose anything to do with a new clause, you must write to the speaker, to the clerk, you must give notice early. All these new clauses, they gave notices. So we cannot have new clauses on the floor. So let me first put a question on the one they've brought, okay? Honorable colleagues, I put a question that clause 19 be amended as proposed. Those in favor say aye, and the contrary nay. The ayes have it.
New clause.
Honorable colleagues, Honorable Lee?
Chair, having established that the role of the minister in checking the excesses of the council has been removed, it is important that we have, alongside the millers, outgrowers, and government, we have the workers represented in the council. The council is a body which takes care of the interest of the various stakeholders. And we cannot be seen to be protecting the interests of a few when the workers in all these growing areas are being exploited. So I therefore move that the workers must be represented in that council so that they are able to take care of the interests of the workers. And they can do that through their representatives or the unions. And that has not been provided for. You have provided for millers, they are 3. You have provided for outgrowers, they are 4. You have provided for government, they are 3. So why should you leave the workers out? And yet they are being exploited every other day. Just as much as you want to protect your outgrowers, you must protect our workers. We are tired of people being exploited. The government should have been the one to stand for these people, and the minister's powers have been removed. So the only protection we can accord these people is by giving them a space where they will be able to express their concerns so that these concerns are discussed and a solution is found for them. I beg to move.
Honorable colleagues, I think you're also going to move that we have cleaners. We also have those, but let me go to our rules. Please, let me go to our rules, okay? I want discipline in the house. Let's go to our rules. Colleagues, we conduct business according to rules. You have been with this bill for long. You have been with the report for long. Rule 134, sub-rule 4 of our rules of procedure. The committee of the whole house shall consider proposed amendments by the committee to which the bill was referred and may consider proposed amendments on notice. That's why members gave me notice. We don't read from here. You've been with the bill, you've been with the report, you've not given notice. Okay? I received, Honorable, you don't access the microphone like that, please. These are not issues of emotions, issues of the law. Okay? And it's not consequential in any way. Okay? Because it is a matter of the law. We have a law which was already giving. If you look at the Principal Act, the Principal Act already gave these people this representation. The Principal Act, it gave farmers 4, it gave mirrors 3. Yeah, so there is nothing like a consequential amendment here. Please, Honorable Jan, please.
Thank you, Right Honorable Chair. Chair, I agree that members intending to introduce amendments should first seek your indulgence in writing. Perhaps that would be the general rule, but I would...
No, not a general rule, it's what your rules say.
Yes, I would suggest that there be exceptions in high-stakes circumstances like we are in at the moment.
So what is high stake about this?
The members' submissions concerning amendments that really affect their...
Honorable, you see, let me tell you, colleagues, you will get a situation where you read from here. Why we give you these reports in advance is to go and prepare. Members prepared. I have Honorable Chobe, I have Honorable Akiki, I have Honorable Taylor, I have Honorable Haji Idi, they all brought in amendments, okay? Listen to me. Listen to me. You have your Principal Act. So, Honorable Jan and members, okay? Now, composition, okay? Composition of this board is in 4. section 4 of the board, section 4 of the act. That's number 1. Number 2, in the bill, again, they also proposed the composition of the board, or of the council. So what I'm meaning is simple. All along, it's an issue that has not just risen. If it was an issue, okay, that had not been provided for example, you insert a new clause that talks about composition of the council, and it has just come. I allow amendments that have just come. But if it is something which is historical, then I don't handle it as an emergency. Please, that's my ruling and that's my guiding. Honourable Minister.
Chair, I want to comfort the honourable member that 1, we have enough laws regarding the labour issues in the country. The second point, the member was worried that the powers of the minister have been removed. That is not true. That is not true. The members, the powers of the minister have been restricted only in matters of licensing. But the minister has the powers to do regulations. The minister has the powers to appoint the council itself. So the member should not get worried about the powers of the minister, though I welcome his sympathy that the minister should have more powers, but the House has said, be restricted, and as far as the licensing is concerned. But other issues really of regulation, if we find that there is a problem in the sugar industry regarding the workers, we come in and intervene. There's no restriction about this. But we have enough laws. We have a whole ministry of employment, labor. There is a state minister for labor, there is a minister for labor. So there should not be a problem. And when we mix so many issues of workers, regulation of licensing of the sugar industry, we can actually get a problem in the sugar industry by mixing so many issues. So I want to appeal to the member that be comforted. The powers of the minister are there. We regulate, we appoint the council, and we have government is in position to handle matters of the workers in the sugar industry like we handle workers of other sectors in the country.
Thank you. I have discussed this with the honourable colleagues. You remember we just passed the Employment Act. Now, it was handling issues of casual laborers, people being denied their jobs and all that. Most of these were covered. But number 2, I've explained to Honourable Lee how it was benchmarked on other laws. When you check the law of Kenya, you check the law of Tanzania and other laws, there's nowhere on the board that these people are involved. And then number 3, even contributing to financing. Because these people are in business with each other. We are regulating a business relationship, how they are interacting with each other. So, but now, you can see what Honorable Guzuri is saying, Honorable Minister. I think the Minister for Labor, we should have time to come and discuss issues of laborers that are exploited, generally, in very many sectors. It can be in cotton, it can be in coffee, it can be anywhere. Yeah? Okay? On which call? Because we finished already, this closing. No, Honorable, please. We don't repeat the same. We have...
New clause.
Chair, 22.
Amendment of Section 22 of Principal Act. Section 22 of the Principal Act is amended. A. In subsection 1, by substituting for the word approval by the board, the words the recommendation of the council and approval of the minister. B. By substituting for subsection 3 the following. 3. A person who wishes to modify a meal shall seek the recommendation of the council and the approval of the minister. C. by inserting immediately after subsection 3 the following. 4. The provision of section 21 shall, within the necessary modifications, apply to an application of modification of a meal. Justification. To harmonize the provision of section 22 with the principle of the bill relating to the grant of licenses by the minister on the recommendation of the council. To request a miller who seeks to modify a meal to seek the approval of the minister.
To require.
To require. Yeah. I beg your pardon, Chair. To require a miller who seeks to modify a meal to seek the approval of the minister. To provide for a procedure for applying to the minister for modification of a meal. Beg to submit.
Minister.
Right Honorable Chair, in light of the discussion we've just had, with the council looking to regulate itself and remove the minister, this was a proposal from the committee. However, in the Principal Act, the modification had always been left with the board, which is now replaced by the council. We propose that we leave the provision of section 22 as it is in the current legislation. Beg submit.
Sorry. Yes. Honorable Batua.
Thank you, Right Honorable Speaker. We've debated severally on the interference of the minister in the works of the council. Honorable Chair and colleagues, recognizing that actually even the chair of the council is appointed by the minister and that there are PSs there, some of these approvals should be left to the council to sort out. They have technical people. Really, we should see minimum political interference with the council. So I pray and suggest that in agreeing to substitute, in agreeing to insert that new amendment, the council should actually do the recommendation, should do actually the approval. We should not have recommendation, but we should have an approval process handled by the council. So the word recommendation should not suffice. Let the process be managed by the council and concluded by the council, and the minister only gets to be informed.
I think that's what the Attorney General was also saying. Okay? Because really, why should the minister be involved in modification of a bill?
So our proposal is that the provision of section 22 of the Principal Act remain as it stands in the bill, in the act now.
Yeah, and that satisfies what Honorable Dr. Batua says. We just do the consequential amendment of the board, just changing the board to council. To council. Yeah. Thank you. Chair, it's you.
Chair, we concede.
But Chair, there was also under that you had changing from board to council. Okay, so we can do it later. We can come back to that.
Right, Honorable Chair, we were proposing that the proposal by the committee be adopted only to the extent that where board appears in section 22 is replaced by council. but the rest of the provision remain as it stands in the Act.
Chair, do you agree with the proposal?
Yes, Chair, we agree.
Thank you. Honorable colleagues, that's very straightforward, Honorable Chibadi. I don't know what you want us to state about that.
You are going to move the motion. But Chair, we wanted the Attorney General to clarify on something which we are passing. In our areas, Chair.
What is something? Here we don't deal with something.
It's the one it's what I'm mentioning.
Yeah,
it's what I'm mentioning, Chair.
Yeah.
Chair, we have used a blanket statement to say meals. Now meals, we have not defined the capacity. In the area where we grow sugarcane, we have cottage industries and jaggeries. And the word modification may affect a person who has a jaggery, just improving it on something, or these cottage industries that manufacture some few things. Is this person also supposed to seek permission from the council? Because these are small industries.
When you're licensing for the sector. You don't license for small, for big. It's a sector.
Chair, this is where the worry is. Now, these people are going to get affected. It's going to affect these people who have these small cottage industries.
Yes, but they should. Because now, Honorable Chibadia, your problem you have been having is simple. That you have a sector which is not regulated. Now, you want to have a sector that regulates some and doesn't regulate others. Let everyone come clean. Let all of them reach in. Then, under the council and in regulation, they will go into the inner details of the small ones, the process of the small ones. They can say, for example, the small one can be handled by the subcommittee, jaggery. Then the big ones can be handled by the full council. Those are details which you go in. But you can't go, you say, we are rejecting people who produce waraji. You say, distilleries, for them, they should be. But we have these ones who use drums and all that, they shouldn't be. No, a sector. What will be the purpose of the law? Honourable Minister.
Chair, the English say you can't eat a cake and have it. You are not going to organize the sector and then also remain with some parts which are disorganized. The reason why we want to regulate this sector is really to bring everybody on board and have the benefits of a proper regulated and organized. So even the small ones, when we are doing regulations, we shall take care of that. We shall take care of that. So there shouldn't be any problem, Honorable Minister.
Honorable colleagues, I want to put a question that Section 22 of the Principal Act be amended as proposed. Those in favor say aye. To the contrary, nay. The ayes have it.
Section 22 as amended.
Honorable colleagues, I put a question that Section 22 as amended stands as part of the bill. Those in favor say aye. To the contrary, nay. The ayes have it.
Clause 13.
Honorable Chair. Honorable Oi Kata gave me notice on clause 13. Huh? It was a kick. You know, I got many. Anyone with an amendment of clause 13.
That is
Honorable, you need a microphone to go on record.
Thank you, Chair. Clause 13, substitution of Schedule 3 to the Principal Act. Clause 13 is amended by substituting for Schedule 3 the following. Formula to determine minimum price of sugar cane. PC, which equals PS times R times D, where PC is average price of sugar cane per ton. PS is average price of raw sugar per ton. R is rediment to be fixed at 8.5%. However, millers and outgrowers may negotiate for rediment above 8.5%, subject to prevailing circumstances. D is the minimum percentage of sharing proceeds shall be 55%. Justification: to provide a fairer formula for determining sugarcane prices.
Honourable Minister.
Chair, I agree with the amendment, and this is one of the things that we have been looking for to harmonize the formula. I want to confirm to the members, because there are some fears from the farmers, that how about those farmers that have already negotiated and signed agreements of the arrangement of above 8.5%. We want to confirm that those amendments, those agreements will continue in force, so they will not be affected. After all, 8.5 is lower than the 9 like Chinyara has already signed. So I agree with the amendment.
Thank you, Honorable colleagues. In the public gallery this afternoon, we have a group of 29 sugarcane growers from Greater Mukono Sugarcane Outgrowers Cooperative Society. They are represented by members of Parliament from Greater Mukono region. They've come to observe proceedings of this house. Please join me in welcoming them. And I can see some of the faces that we had in the negotiations that took some. Chair, thank you. Thank you. Honorable colleagues, in the public area this afternoon, we have a group of Scouts and Girl Guides leaders from the Uganda Scouts and Girl Guides Association who have been participating in a meeting with regards to the amendment of the Boy Scouts and Girl Guides Act. They are here to observe proceedings of the House on invitation of Honorable Sasaga Isaiah, Member of Parliament for Budadi East, who is also the Deputy Chairperson of the association. Please join me in welcoming them. Thank you. Honorable Batua.
Thank you, Honorable Chair. On the issue of rendement, I do not want to differ so much from what has been agreed. However, my contribution is that the 8.5% should actually be the minimum. My argument is that if we are to understand rendement as how sweet your sugarcane, you the farmer, how sweet your sugarcane is, and we who grow sugarcane, we know that when you leave it for long in the garden, it becomes sweeter. Therefore, rendement meaning that 100 tons of sugarcane, how many tons of sugar will it give? Here we are saying 8.5 tons of sugar.
Minimum.
Minimum. We are saying the word negotiation should not arise, saying that those who negotiate for a higher rendement. Let there be a procedure in that those whose sugarcane has been tested and found to produce more than 8.5 at least get what they deserve. However, the minimum remains at 8.5.
Yeah, Honorable, those are issues which the Council will handle
in their regulation.
Yeah,
the word negotiate, Honorable Minister, should not arise. We should be fair to a farmer who has fertilized and given long for the cane. Thank you very much, Honorable Chair.
Honorable Diomu, really, you want to comment on this? Honorable colleagues, I now put the question that Clause 13 be amended as proposed. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 13 as amended.
I put the question that Clause 13 as amended stands part of the bill. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 14.
I put the question that Clause 14 stands part of the bill. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 1.
I put the question. So, Honorable, these are clauses we stood over because we needed to first sort these issues. Honorable colleagues, now that we have sorted these other issues, I put the question that Clause 1 stands part of the bill. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 2.
Honorable colleagues, I put the question that Clause 2 stands part of the bill. Those in favor say aye, and to the contrary nay. The ayes have it.
Title.
Honorable colleagues, I put the question that the title stands part of the bill. Those in favor say aye, and to the contrary nay. The ayes have it.
Motion for the House to resume.
Honorable Minister.
Mr. Chairperson, I beg to move that the House do resume and the committee of the whole House reports thereto.
Honorable colleagues, I put the question that the House do resume and the committee of the whole House reports thereto. Those in favor say aye, and to the contrary nay. The ayes have it. Thank you.
Report from the committee of the whole House.
Honorable Minister.
Mr. Speaker, I beg to report that the committee of the whole House has considered the bill entitled the Sugar Amendment Bill 2023 and passed it with amendments.
Motion for adoption of the report from the committee of the whole House.
Honorable Minister.
Mr. Speaker, I beg to move that the report from the committee of the whole House be adopted.
Honorable colleagues, I put a question that the report of the committee of the whole House be adopted. Those in favor say aye, and to the contrary nay. The ayes have it.
Bill third reading.
Honorable Minister.
Right Honorable Speaker, I beg to move that the bill entitled the Sugar Amendment Bill 2023 be read the third time and do pass.
Honorable colleagues, I put the question that the Sugar Amendment Bill 2023 be read the third time and do pass. Those in favor say aye, and to the contrary nay. The ayes have it.
A bill for an act titled the Sugar Amendment Act 2025.
Thank you. Thank you, Honorable Minister. I want to congratulate you. I want to congratulate Chair. I want to congratulate members from the sugar growing areas and honorable colleagues for supporting them. You know, the members, and I want to really thank in a special way members who participated in the negotiations to listen to their farmers. These outgrowers here are very happy that at last, we have this resolved. Because then I will raise Honorable Kuzuru's issues later. Because every day we have been laying, these outgrowers have been suffering. Even when we've been putting government on task here to come and address issues of the sugar sector, our cane, we are getting a low price, there was no basis. The basis was clear in this, especially that formula. So, Honorable colleague, and thank you for fighting for your people and guiding us. They were hard, and there is no way presiding officer could proceed without first reconciling with the colleagues from the sugarcane growing areas. Now, for the outgrowers and farmers, colleagues had a fear that there are people who didn't want this law to pass, and therefore will go and blame other colleagues. Whatever you didn't achieve, it's because your MPs went and passed a law. What we have passed here is what was negotiated between the millers and the outgrowers. The MPs came to support and to ensure that indeed you get a fair deal. So I don't want my MPs to be blackmailed or not supported. It might force some of us to come and explain to people who negotiated. So those who negotiated, please let us stand by that negotiation and explain to our people why it was very important to pass this important law. Honourable Minister.
Mr. Speaker, I want to thank you in particular for all the effort you have put in to make sure that these amendments are passed. You have chaired several meetings We have negotiated, built consensus, and it is this consensus that actually we have passed. I want to thank the members for supporting the amendment. We passed the law in 2020. It has been now coming to 5 years. I want to assure members that now we are going to work on the regulations. They might even come before the 4 months so that we implement the sugar bill and organize the industry. And I think, Mr. Speaker, could be an appropriate time that we check our sugar levels at this time. I thank you.
So, Chair, we made you suffer, inheriting, a bill in between, but you've done a fantastic job. We want to thank you. Please, if you have any comment you want to make as a committee chair, please.
Thank you so much, Mr. Speaker. Allow me to join the Honorable Minister to thank you for the tremendous job you have done. I would be very honest, first time I joined the meetings for the millers and the outgrowers, I thought it would not get an end to this, but I would like to thank the growers and the outmillers for finally having something on table, and definitely I'll thank the fellow honorable colleagues from the sugarcane growing districts and constituencies. They have joined you in this battle and it has been successful. Thank you so much.
Thank you, colleagues. House suspended for 30 minutes so that we can do lunch and be back here in 30 minutes.